Hello and welcome to LiveLaw. My name is Padmakshi Sharma and today we will be talking about a new development in the Maharashtra political crisis. To briefly provide our viewers with a background of the issue, the Maharashtra political crisis started when Shiv Sena leader Eknath Shinde announced a rebellion and found support of many MLAs within the party. You may recall that Eknath Shinde had earlier filed a writ petition challenging the disqualification notices issued by the Deputy Speaker to rebel MLAs for proceedings under the 10th schedule of the Indian Constitution over alleged defection. A Supreme Court vacation bench comprising of Justice Suryakant and Justice Pardiwala had heard the matter and kept in abeyance the Deputy Speaker's disqualification proceedings in petitions of Shinde and other rebels. Meanwhile, the floor test was challenged in a petition filed by members of the Uddhav Thackeray faction. However, the Supreme Court turned the request to stay the floor test. Uddhav Thackeray resigned from the post of the Chief Minister of Maharashtra following this, and Eknath Shinde was sworn in his place. Yesterday, a three-judge bench of the Supreme Court of India, comprising of the Chief Justice of India N.V. Ramana, Justice Krishna Murari and Justice Hima Kohli, heard the 6 petitions filed by the Eknath Shinde and the Uddhav Thackeray factions of the Shiv Sena party in relation to disqualification proceedings, election of speaker, recognition of party whip, and floor test for Shinde government in the Maharashtra Assembly. CJI N.V. Ramana orally remarked that the issues arising in the petitions, such as the consequences of removal of paragraph 3 of the 10th schedule, absence of split concept, and whether a minority party leader had a right to disqualify the party leader or not, may have to be referred to a larger bench. At the outset, CJI Ramana stated that he had some doubts regarding the consequences of deletion of paragraph 3 from 10th schedule. For context, paragraph 3 of the 10th schedule originally stated that members of the House shall not be disqualified under the anti-defection laws of India if a political party underwent a split and not less than 1/3 of the members of the original political party were part of the newly formed faction. However, this paragraph was omitted by the 91st Constitutional Amendment Act in 2003 on the ground that the 1/3 split rule was grossly misused by parties to engineer divisions and indulge in horse trading. 1/3 was regarded as an easy target to achieve, and the law now exempts defection only when 2/3 of members join a new faction, and that too in a merger. The CJI also stated that the concept of split was not recognized anymore and inquired what the consequences of the same would be. To this query, senior advocate Harish Salve, appearing for the present Chief Minister Eknath Shinde, submitted that there was no need to look into paragraph 3 and the issue was confined to paragraph 2 of the 10th schedule alone. Let us now briefly have a look at the arguments which were raised in the court. Senior advocates Kapil Sibal and Dr. A.M. Singhvi, appearing in petitions filed by the Uddhav Thackeray group, argued that since the rebellion group violated chief whip, they are disqualified as per the 10th schedule. Senior advocate Sibal submitted that 40 members of Shiv Sena, by their conduct, are deemed to have incurred disqualification by giving up party membership as per paragraph 2 of the 10th schedule. Paragraph 2 provides for disqualification of members of House on the ground of defection and states that if a member has voluntarily given up membership of the political party that he belongs to, he will be disqualified from being a member of the House. Senior advocate Sibal argued that if such rebels are allowed to form the government, then every elected government can be toppled despite the bar provided under the 10th schedule. He also submitted that the only protection in such circumstances was for merger under paragraph 4 of the 10th schedule. Here, paragraph 4 exempts members from being disqualified in case their political party merges with another political party. Senior advocate Sibal stated that the condition for exemption in 10th schedule was not just having 2/3 majority alone, but also that such two-thirds majority must merge with another political party. It was also submitted that the protection under paragraph 4 of the 10th schedule was not available to the Shinde faction since they did not merge with another political party. Senior advocate Sybil further submitted that the governor should not have sworn in the new government when the Supreme Court was still hearing the matters. He stated that a speaker recognizing a whip other than the official whip nominated by the party was malafide, and when disqualified members elect a leader, then the election itself is bad. He urged that the records of assembly should be called for, and meanwhile, Eknath Shinde should be stopped from occupying the CM's office. In light of these arguments, he also requested the court to direct interim disqualification in the matter. Senior advocate Salve, on the other hand, argued that the disqualification proceedings initiated by the Uddhav faction have throttled the inner party democracy. He argued that the 10th schedule cannot be attracted when a large number of people in a party feel that another leader should be leading their party. He stated, and I quote, that raising voice within a party without crossing Lakshman Rekha is not an act of defection. Thus, he argued that the court should refrain from interfering in the workings of a political party. Solicitor General of India, Tushar Mehta, clarifying that he was speaking as a counsel and not as a representative of Maharashtra governor, stated that the court may also examine issues relating to breaking of pre-poll alliance and the issue whether a group of members going against the party leader to fulfill the pre-poll ideology promised to the electorate would attract disqualification. The matter is now listed for discussing preliminary issues on 1st August and status quo order passed by the court on July 11 to keep in abeyance the disqualification proceedings continues to operate. The court, after hearing the counsels, agreed that some issues may be necessary to be referred to a larger bench. The parties were directed to frame the preliminary issues and file the same. Thank you for watching LiveLaw. Subscribe to our channel for similar content.